I'd now like to welcome representatives from the Queensland Conservation Council and also the Yugambeh Jagera traditional language country. We've got James and Louisa. We have Dave Copeman, the Director of the Queensland Conservation Council, and Louisa Bonner from the Jagera Traditional Language Country. Great to see you this morning. Would you like to both make a short opening statement, and then the committee will have questions for you?
Yeah, thank you. I got to turn it on. Sorry, guys. Thank you for the opportunity to present. Queensland Conservation Council is a peak body for environmental organisations in Queensland. We represent tens of thousands of Queenslanders across 60 plus member groups, all of whom want to see strong climate action and want to see nature protection. And we want to make sure that Queensland is able to welcome the world to the Olympics in 2032, where we're showing visitors a vibrant, living Great Barrier Reef, opportunities to see koalas, an iconic species living in the wild in southeast Queensland, and also showcasing the ongoing cultural practices of the oldest living cultures in Earth. But we're very concerned that we're not heading in this direction to achieve these goals, and that most of the elements of this bill would actually make them harder to achieve. So these amendments, I think the first thing to say about them is that they're poorly drafted. We don't think they're actually achieving some of the goals you're trying to achieve with them. We think it's a very dangerous precedent to exempt development from planning and environment laws or to weaken cultural heritage. We shouldn't do that lightly. And while we welcome the rhetoric around community benefits and community consultation, we really question whether this bill will actually achieve this for renewable energy projects. We think you should probably go back to the drawing board and do a bit of work to make sure that the bill achieves those goals, because we don't think the current revisions do it effectively. And I mean, it is incredibly inconsistent that this bill is trying to apply greater consultation to renewable energy projects and literally ripping up any process for community consultation or our existing laws for Olympic facilities. Like, the hypocrisy is kind of blinding. I think that we've got a great set of, well, no, that's not fair. We've got a set of laws that we can use. We've had lack of clarity around the decision-making process for the games, but that's had nothing to do with our planning processes. That's had to do with changing our mind on when stadiums are. We've got enough time to build the facilities we need while honouring our existing laws, and to rip them up just feels like it's actually going to be risky. It's going to endanger the timeline toward the Olympics by creating legal hurdles, and it's going to create, I think, a terrible story to tell to the visitors who are coming. You know, welcome to this great facility where we got rid of the rights of First Nations people, but we want to celebrate their culture here. Welcome to, and you know, both of these bills are dealing with urgency. We've got real urgency on the renewables transition. We've got real urgency in getting the games built. But I think it's one of these cases where you probably want to hasten slowly. I think if you create fundamental legal challenges because you're trying to get rid of the inherent rights of the Supreme Court to review processes, that seems like a way to risk a timeline, not to protect it in relation to the Olympic bills. And also, if you're putting complicated barriers on councils for the assessments of of community benefit schemes and social impact assessments, you're actually delaying the transition instead of assisting it. We think good planning is at the heart of both a good Olympics and a good rollout, but this bill is not achieving good planning. In the renewable space, we should be doing renewable energy zones where the community is told, okay, this is where we want things to go in this area, and then you look at absolutely the community benefits and the social impacts, but with some guidance to where things should go, instead of putting a somewhat arbitrary review mechanism over each individual project with no clear guidance of how we should design our grid and how we should design our transmission and the generation in a way that's going to work most effectively. So, I mean, that's what we would encourage the committee to think about. But I'd take your pencils out. Like, we don't have much of a review process in the Queensland Parliament. We're unicameral. You're it. And I think there's some real work for this committee to do to make a strong recommendation to fundamentally review some of the problems we've got in these bills on both the Olympics and on their renewables rollout.
Thank you, David. Louisa, just bring the microphone across to your mouth, if you would, mate. Yeah. Press that.
Oh, look, I'm all for the advancement of our country and our nation for our people. But I'm a First Nations people from this country as well, and I've grown up with stories and history, not all of it being pleasant, and a lot of it being struggles. And I don't mean like real struggles for me, but I was very, very blessed with my mum and my dad. But our First Nations people, you know, we've been dispossessed in history of this nation. We're a people still grappling with the ability to stay ahead with government. There is no support for us. We don't have a place like ATSIC anymore, which no longer exists, that can be a voice or lead or talk for us. You know, we're fragmented all throughout the country and have leaders trying to come up every once a year on Australia Day, sadly. Our voices then are very distant and we don't get heard because we're not up there, we're not leading, we're not consulted. And I believe our consultation as First Nations people is at a different level to the everyday lay community. You know, we're doing consultations. The government's trying to do consultation with us through developers and all these fantastic ideas and businesses that are coming forward. But to be honest, if something like this goes forward for us as First Nations people when it comes to our cultural heritage, with negotiations with the government, our cultural heritage and our rights depend on having some kind of a benefit from it. And it really is already a weak legislation, the Cultural Heritage Act. You know, we have to rely on the local governments to link us up with developers, and even still, they don't even have to actually do that. Do you know that? They can actually still move ahead without us, without consultations. So it's up to the integrity and the generosity and the kindness, if you like, of those developers that come to do work. That's how weak our bill is. This will disadvantage us even further. What negotiation rights will my people actually have? They will be watered down to virtually nothing. The gentleman sat here and said that he did consultations with community, and he asked a question about, I'm just trying to put it into my words, but my understanding is that if this bill passed, they're in control of further consultations. And I can guarantee you now, because I've already seen things happen before, and I sit as a member of our Yugambeh applicant, and I'm also a member of Yugambeh, and my country goes right along to Bundjalung and back through Warwick to get the bull as well, and I know a lot of his other mob. But sorry, I'm losing my train of thought, but our negotiation rights will leave us, I'm sorry, I've just lost it. Let me cut for a second, if that's okay, if I have a second.
Louisa, just while you're thinking about that, and you referenced about a question I asked of the other gentleman, it doesn't mean that they are in charge of the consultation. Until this passes, there is no requirement for them to do consultation. So this bill will make sure that they have to make requirements with the community and local government. It must be meaningful, so that it's not that they're in charge of the consultation.
Yeah, but how does that happen? How does this bill ensure our rights and our rights as traditional owners, that government's negotiating with us and government's up here dictating these things? Just let me talk plainly, I don't mean to be rude, I've never grew up racist, but white fellas have the advantage in every aspect, in every area, to come even up to the desk like this and sit and talk like this. I've never seen. I thought, wow, this is how it happens. Mm-hmm. Is this what we should be doing as well? Well, maybe that's what I'm supposed to be doing here today, to make sure that bill doesn't go through without proper consultation and the government actually treat us like the applicants that you're actually negotiating with us. You know what I mean? Not down here, not anywhere else. Negotiate with us first. Give us an opportunity. We are disadvantaged. We're disadvantaged socially, economically, I would say in knowledges and wisdoms that is far-fetched from our cultural ways and things like that. We're having to learn white man's language, the knowledge of the European settings, as in states and governments and legislations that we barely understand how they work. That's all for now.
Thank you, Louisa. Go to the Deputy Chair.
Thank you both, Louisa. You're a fantastic advocate and you've done a great job today, and we will have some questions for you. But my first question I will put to Dave, if that's okay. Dave, thanks for coming along. We were in the regions yesterday and heard from many locals who are neighbouring solar and wind projects who do have some concerns about the environmental impacts that these projects are having on their local ecosystems, water degradation and microplastics. I was interested if the Conservation Council shares those concerns, and perhaps if you could speak to any feedback or comparisons that you have on the impact of coal and gas versus wind and solar, both in terms of emissions and potential impact on environmental ecosystems.
Yeah, sure. Thank you, Deputy Chair. The first thing I do want to say, by the way, this is the first time QCC's been consulted. We weren't invited into any other processes. We do note the incredible inconsistency that these new laws would create. So that what we're seeing here is that, it requires community benefits and social impacts. But at the same time, if you're proposing for a coal mine which is less than 2 million tonnes run of mine, you have no requirement for environmental impact assessment, and as a result, you have no social impact assessment required for that. Now, Gemini coal mine, there's an example I think we reference in our submission where there's a coal mine that's just surprisingly below 2 million tonnes annual run of mine a year. So that impacts, some 2,000 hectares. No requirement for a social impact assessment. This would mean that, a small wind farm, maybe, or a small solar farm that's only a couple of hectares would have to have a social impact assessment. So it really is inconsistent, and those coal mines are, particularly in the Bowen Basin where they're really gassy, they're emitting huge amounts of methane, which is having big impact on the Great Barrier Reef because it's driving climate change. But I think also what's important to state is that these laws actually don't do anything to improve environmental protection. So there's no, in spite of the fact that people are raising concerns around the environmental impacts of wind farms in particular, there's nothing in these laws that actually does anything to improve that. And what we're seeing is instead a very arbitrary system, so the mechanism at the moment for the review of projects that have already been approved, there's no clear guideline about whether a project would be exempt or not. It's at the discretion, it seems, of the Deputy Premier to decide something's exempt, and that's consistent with some recent decisions we've seen where projects have been called in, and then it's not clear on what basis some have been rejected and others have not. As a general principle, when we're making planning approvals, it shouldn't be arbitrary. There should be guidelines, there should be criteria in terms of the natural impact. And what we're seeing in here is, particularly for the retrospective act of the legislation, the creation of an arbitrary mechanism. And that's not good. That's not good policy, it's not good practice. In worst case scenarios, it leads to corruption. In best case scenarios, it leads to inconsistencies and a lack of clarity about what proponents are actually meant to do.
Can I ask just a clarifying?
No, we'll go to the member for Mulgrave.
Sure.
Me or
Go to the member for Mulgrave, thanks.
Me?
Yep.
Cook.
Oh, sorry, member for Cook.
Sorry. Dave, you just seem to cast this law aside out of hand, and you can correct me if I'm wrong, but yesterday we inspected a site called Lotus Creek, which had been approved for wind farms, which ultimately turned out to have over 100 koalas found on that site, now under existing legislation. So we're now bringing in a regime, and the EPBC Act isn't pushed aside or anything else, all those other protections, but we're bringing in a regime that creates far greater community consultation and community benefit beyond just some token couple of $1,000 per wind farm, and mandates consultation and agreement with traditional owners, not only impacted with the land but beyond. I just see a terrible inconsistency there, how you're not supporting this legislation. You just cast it aside and tell us to get our pencils out. I don't understand that, because those koalas would be protected under this regime, not just bulldozed.
Just to clarify, We support the intent. We just think you've done it very badly. The intent of community consultation is something that Queensland Conservation Council has supported for a long time. We were raising for a long period of time. The key problem we saw with State Code 23, which is the code that makes wind farms code accessible. One of our main objections is there was a lack of community consultation and there wasn't adequate environmental protection. But these new provisions don't increase the environmental protections. So those 100 koalas you raised, there's no reason that anything, and I can't verify that fact, but I can't say that anything in here would change that. So, you know, I think that's important to note in relation to these things. There's no improvement in environmental protections here. What actually we need to do, if we're to plan wind farms correctly, is where we need to get renewable energy zones. So we can say, okay, where do we build the transmission and the network so that wind farms can be built in an area where you've got good wind resource, but you also can avoid remnant forest, which has significant biodiversity values. We've been pushing for that for years. We've been banging the table on that for years. The previous government, I think too slowly, were progressing towards that, but this government doesn't seem to be progressing renewable energy zones, and instead we've got a mechanism that puts procedural requirements for consultation but no protection of the environment.
We'll go to the member for Aspley.
Thank you, Chair. Mr Copeman, I note in your opening statement, and thank you for appearing today, as well as Louisa, about there's no specific environmental values listed or protected or furthered by this proposed bill. In terms of, we've heard yesterday in the committee hearings that from some renewable energy proponents saying this would delay projects by 6 to 12 months and this just adds to their costs. It makes the projects less viable, makes them less likely to get up. Do you see that as an outcome of, or do you agree with them that this is one of the main outcomes of this bill rather than actually protecting environmental values?
Yeah, I think this, as it's currently drafted, particularly when you're asking for these, and I think I wasn't here earlier, but I'm guessing the renewable energy proponents would have said the same thing as I'm saying because I saw the submissions. Putting it in at the DA level, many cases you've got maybe a gigawatt of capacity in a particular network and you've got 10 proponents in that area all trying to get up half gigawatt size wind farms. Now only 2 of them are going to get up. But if you're saying for each of them at the DA level, they've got to go and do the community service obligation, they've got to do the social impact obligation, you delay them all, you put greater pressure on the council, greater pressure on the community, and 8 out of 10, you're actually wasting everyone's time and you're just slowing things down. I mean, we need to see the rollout built in an orderly, measured manner. This bill doesn't help us with that. We want to see the community benefits and we want to see community involved in the planning process. This bill doesn't provide the mechanism to achieve that because it's looking at it individually and at the wrong time in the cycle. So I think, yeah, keep your community benefit scheme, absolutely. Keep your social impact assessment, but do it at a renewable energy zone level and do it at the point where you've got your DA and you're moving towards the process of implementing the projects, and then we would thoroughly support it.
Yeah, thank you, David. Thank you, Louisa. I've just got a couple of questions and a couple of things to clarify for you. So, firstly, David, this bill in no way impacts on the renewable energy zones. They are there, and it certainly is not about stopping renewable energy projects. Renewable energy projects are important for our community, but so is affordability and reliability. So, is it that you thought that the system before this bill was okay, that there was no consultation?
No, I literally just said that in the last question. We strongly opposed State Code 23 and we called for its reform because there wasn't community consultation. Right. We wanted to see consultation. There aren't currently renewable energy zones that are planned. So the Australian Energy Market Operator specifies a renewable energy zone where you've got network or transmission and you've got a range of different projects all connecting up to the grid in an integrated process. Now, the previous government was progressing that. We don't yet have the kind of renewable energy zone plans that we still want to see, that community deserve, that actually say, okay, we're going to build the network here or the transmission connection points here, and this is where you connect. So you're right, this bill does nothing in relation to those renewable energy zones, and that's the problem. That should be how you should be planning the implementation and the community benefits, instead of every single project that may or may not progress being asked to do a community benefit scheme that may or may not be of any use to the community, a social impact assessment that may or may not connect to their interests. If you actually got the reses sorted and then you said, okay, what's the social impact? I mean, you also get economies of scale. You're able to say, okay, as a community, let's be involved once in what we want to see in this area. Let's be involved once in what we want to see as a benefit for our community, instead of every single proponent coming in a different way and doing it.
Yeah, sure. You mentioned before about the call-in that the Deputy Premier did about the Moonlight project.
The 3, yeah.
Yes, up there. You know that week or about that same time, there were 2 other renewable energy projects approved.
Yes.
Yeah, good.
What I don't know, though, is why.
Okay.
I don't have any clarity about the ecological values or the criteria or what the mechanism was that meant of these 3 that were called in, why Moonlight was rejected and the other 2 were approved. I mean, I understand that there is concern around the ecological impacts, but I don't think they were the primary ones, but I don't know. And that's not good policy to make planning approvals in that manner where there's not clarity around the elements of the decision making.
The committee went for a tour in a charter plane yesterday to see some of these projects, and when you see the expanse of remnant vegetation in that area, you can understand why there's some concerns. I just wanted to go back to your submission, though, and touch on a couple of things for the Olympics as well. So I note that the bill continues to require games venues adherence to the federal EPBC Act, and your comments regarding there's now no heritage protection. Do you acknowledge that, as described in the explanatory notes of the bill, it maintains the requirement for engagement and meaningful consultation with the relevant parties and preparation of a cultural heritage management plan?
Sorry, when we said there was no consultation, we meant under the state regime. We're not suggesting that this law changes federal law. So yes, there'll still be federal requirements to consult under the federal cultural heritage provisions.
Sure.
At a state level, we just think, I mean, you can almost hold up the rushed process by which the consultation for this bill went about and replicate it to the rushed process that this bill suggests for cultural heritage consultation. And you've almost done an experiment, I think, in how effective the new bill will be, because in this process to consult on the bill, I don't believe you've seen significant First Nations engagement because you've had a really rushed process. And I think that you're setting yourselves up to fail again in terms of the new mechanism that you've created, which is a very rushed process. You're establishing a whole new mechanism for cultural heritage review and assessment. We don't believe that the existing cultural heritage laws are working, and we actually prioritise the review of the First Nations cultural heritage in line with the Environmental Defenders Organisation's advice into this. But we're deeply concerned that we're going to see a rush to this process. In particular, I mean, the fact that your own legislation is incompatible with human rights, and that you've got a human rights compatibility statement that says that it may interfere with people's ability to practice their cultural rights, and you are going to be limiting that. And the fact that you've got and I mean, I'm going to my submission here, you've got extremely short timeframes of engaging with a proponent of a minimum of 2 weeks in most cases. This is not what we should be doing. This is not... How do we say to the world, let's celebrate the most incredible old traditions here, but we stuffed up their culture and we gave them a 2-week period to have a say about it, and that's what we think we're doing when we're inviting the world here and saying, let's celebrate these cultures? That's not what we should be doing. It makes me feel sick to my stomach that once again this parliament is dispossessing Aboriginal people of what limited rights they have for the sake of a political football.
But hang on, David, you just agreed that under the previous regime there was no requirement for consultation, and now we're embedding that in this process. So, Louisa, you've been wanting to say something in regards to my question?
Oh yeah, you can turn that on. I got to turn that off.
Oh, there's just so much when it comes to addressing this sort of thing. Like I said, we don't have any party or any group or finances to address these things, and nor do, or an entourage. an army. I'm a single mother, you know, working, whatever, blah, 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 and been out there doing cultural heritage works, understanding how the local councils work, and can work if they want to, because of the legislation that's very weak, that disempowers any, negotiation rights that we can have with community. Not that we're being a whinge, but it's like, you know, we're talking about a whole nation, you know, dealing of First Nations trying to deal with the system that we have. It doesn't, you know, consultation. What is consultation? What is it? What am I sitting up there as an applicant for in negotiation with the government? You know what I mean? If we're having to, these things are being passed under us and we don't have the knowledge and we don't have any input in legislations about First Nations people's rights and negotiation rights, and they're being taken right out from under us or weakened, you know? It's not that we don't love our country. We care about the koalas, we care about the gum trees, we care about the rivers, we care about the waterways, because for us, that's our life. Anything that goes wrong with that, you know, that's lessens our longevity, you know, on this earth, you know. So we care about that for both black and white, if you like,
Sure.
whatever.
Just my last question is in regards to your submission, David, and you talk about being able to, you know, celebrate cultural heritage at the stadium at Victoria Park, and maybe, Louisa, you could think about this. How could we best celebrate cultural heritage at that stadium, as you reference in your submission?
I'm not an expert, and I'll defer to Louisa on the cultural heritage of that site, but I think, can I just give you an example? So I'm on the stakeholder reference group for Barumba Pumped Hydro, and one of the things that's been going on in that process is that as you go through the process of planning and developing it, there's been, I think, quite strong engagement with the Cubby Cubby as the traditional owners, and they've gone and been involved in reviews, and they've gone out on country and they've looked at, okay, where are particular areas, because in some of those areas they haven't had access, and now they do. What I'm worried about, and so there's actually been I think this government, previous government, both governments have done a good job in adapting to things that they've found. What's the problem with this legislation is you've got a 60-day window to nominate and negotiate an agreement, and then you explicitly prohibit that default plan from being amended or replaced, so that if you as part of a process you discover new cultural heritage, you're digging things up and you find a midden site or a boral ring or other things like this, you're explicitly prohibited from amending or replacing the plan. I don't think that's good practice.
Just your microphone again, Louisa.
Yeah, I mean, it does. I can rattle on all I want, but yeah, unless we're involved in the initial consultations about what's happening in country and how that affects us and impacts us as well, then, you know, we feel like we're being dragged along to have to agree with something. It's not that we either agree or disagree, it's just we don't have that depth of relationship or consultation or understanding around that, or even consideration. And that's all I can really say on that.
Got a quick question, Chair.
Yeah, Member for Bancroft.
Yeah, just to Louisa, and just on that, I note the current practice is you've got 1 month to notify instead of 2 weeks under this bill, and then you've got 3 months to negotiate under the existing law instead of 2 months, for example, there. And you said negotiate with us first. What do you want to see happen at Victoria Park at Barumba?
See, it's really hard to continue that conversation when I just said what I just previously said, because you're forcing me to respond to something that, you know, it could possibly be very well good for community. There's a lot of positive stuff that's been said. But for me, it means going along with something that impedes upon my rights and you know, and my responsibilities to community, to the land, you know, to the waterways. So how do I really engage in this conversation? That's where I'm at.
That's fine, Louisa.
Can I follow up to that?
We're out of time.
I'm happy to
Deputy
go over
Chair.
time. I think it's really important that we hear from Louisa. We don't have many people on this whole panel speaking about the cultural framework, and I think it would be useful to unpack a little bit about that if they're happy to stay on for an extra 5 minutes.
The time for this session has now ended. Thank you, Jonty. We do have other cultural traditional owners later on in today. So, and Louisa just answered the member for Bancroft to say that she felt that she should be talking to her community to be able to develop those things. That was quite clear, and I thought that was very respectful. So thank you, Louisa, and thank you for the representation you make for your community. The time for this session has now completed. There's no questions on notice, so you don't have any homework to do either.
I'm happy to talk afterwards with you out there if you like.
Prefer that we talk on the record, to be fair. I think that's actually
That's
important.
I
not
can
going
talk
to
pretty
happen.
fast, Jim. I can talk really
Yeah,
fast.
it's really
Louisa,
one quick
thank you.
question.
I'm happy for us to go on our lunch break too.
Yeah, we're happy to give up the lunch
Thank you.
break
We will
to you,
now
Louisa.
take a 45-minute break, and we'll
Shame.
resume at 12:45. Thank you.
See, I don't have the power. It's up to you guys.
Thank you. Good afternoon. We now resume this public hearing for the inquiry into the Planning, Social Impact and Community Benefit and Other Legislation Amendment Bill 2025. Welcome, Aunty Sandra King, one of the traditional owner representatives. If you'd like to make an opening statement, and then the committee will have questions for you. Just push the microphone so you can start.
First off, I would like to say welcome to Yagara country and also to Mugajin, the traditional name for Brisbane. And it's not Mianjin, as everybody has thought it was. So it is Mugajin. Mugin, M-A-G-A-N-D-J-I-N. Mugin. That is the traditional name for Brisbane. And I'd like to welcome you all here and pay respects to my ancestors and to all the ancestors and to elders past and present. Yes, my opening statement, I have no idea what to do. So I think as a Yagara person, I would like to see something change with regards to the law, where it has, it states that when groups of people have put in a statement for the claim for a country, after that, nobody else can put a claim in. And we can't put a claim in, so as Yagara people. So that's what I would like to put first. And also, I was Mugajin born and bred. In fact, my first home was Victoria Park. And I have photographs of that. And I don't approve of the Olympics being set at Victoria Park, especially when there has been no consultation with the traditional people as well as with Aboriginal communities as such. Okay.
Thank you, Sandra. I have to listen to my own instructions about pushing the microphone. I'll go to the member for Cooper for the first question.
Thanks, Jeff. Thank you, Chair. Thank you, Aunty Sandy, for coming along today. Have you had a chance to have a look at the bill? Are you aware of kind of what's in like all of the elements of the bill, or would it help if I?
No,
Yeah.
I've only received something this morning, but I had a presentation to do this morning and I haven't looked at anything.
That's
so
okay.
I apologise.
No pressure. No pressure at all. I just wanted to, I guess one of the things that we're interested in, which we didn't have the chance to unpack in our last session, is an aspect of this bill is looking at the Olympics. And if GAICA approves a place to be a stadium, then basically it circumvents, I think, 13 or 15 different acts, including the Cultural Heritage Act. And it sets up a whole new cultural engagement framework. Now, under that framework, the proponent has to identify the traditional owner group and issue a notice to them or publish it on their website, and that traditional owner group has 10 days or 14 days, to respond. And then if they want to negotiate, a 60-day negotiation period. And I guess I was just interested in your views around, that's quite different to the Heritage Act at the moment, and whether you had any thoughts on that, whether that would be beneficial for your community, whether it would be difficult for your community.
Well, the Cultural Heritage Act at the moment, I've got reservations about it, only because that it has stated that the last man standing can put a claim into Brisbane, and that is where Marucci had put a claim into Brisbane because of the cultural heritage list. Therefore, she's still claiming to be an elder, even though she does not come from this country. So I do have an issue with the cultural heritage list. But if you are going to change it, I'd like to see that part taken out, but I'd like to see something else put in, you know, so if we, as the Yagara people, can put in a claim, but because of the law, it states that we can't. So we're in a difficult situation at the moment, and we always will be until the law can change. So the Cultural Heritage Act, however it is written, it needs to be approved or been looked at by the First Nations peoples. Yeah,
So
that's what I feel.
I guess under this bill, what it would do is the proponents, the person doing the stadium essentially would essentially be able to do what they like. They would be required to do a cultural assessment and framework and make that available to a traditional owner group. But if that group can't be found or doesn't engage in the timeframes or doesn't agree with it, it will simply default to the proponent. So things that you might like to see included in that will simply not be seen.
Yeah.
Does that concern you?
Yeah, it does, you know. Oh, sorry. Yeah, sorry. Yeah, all right, I kept my finger on it. Yeah. Is that all right? Yeah, okay. Yeah, I like to see something happen, you know, but as the Cultural Heritage Act, I think you would like to work with the First Nations people of the Yagara people. We do have an elders Yagara elders group, Yagara Muggajan Aboriginal elders group, so we can look at it, you know. So yeah, we have a few people that are on that committee that will be able to look at it. Yeah, so either way.
Thank you, Sandra. It may be of some comfort to you that the explanatory notes of the bill does establish and maintain the requirement for meaningful consultation and engagement with relevant parties, and also the preparation of a cultural heritage management plan.
Okay.
So some of the submitters has talked about the opportunity to make sure that we have cultural heritage included in some of the places, including one submission actually said there could be opportunity for cultural heritage involvement with a stadium at Victoria Park, in fact. If you turn your mind to that, what sort of things could you do, or what process would you like us to take on board to make sure that there was meaningful engagement in that cultural protection?
I would like to see that if it does go ahead, the Olympic Stadium, I would like to see a cultural heritage shelter set up there or something for everybody to attend. Aboriginal groups can put in their history about Brisbane, and we can go back, you know, and show our ancestry line going way back thousands and thousands of years. But I think that is a step in the right direction if that does happen. You know, I hope it does happen because we can put a lot into that. And for people who are born and bred in Brisbane, they can also put a lot into it as well. So yes, as with my family and can be able to put in information, because my father, I suppose you can say that he was a storage person who just held on to things. And we found so much information that my father had regarding his family going back to late 1800s and mid-1800s. So, yeah, that information can be added because it'll help people to understand the history of Brisbane, and the truth-telling is so important at this stage. So I feel that it can benefit everybody. Yeah.
For sure. We'll go to the member for Bancroft for the next question.
Yeah, thank you. Thank you, Aunty Sandra. I'm focusing on process. Okay, so as a cultural heritage management plan comes through, mind you, it's negotiated over a shorter time frame, 60 days instead of 90. If, you know, for example, if there are artefacts or evidence discovered there, how important is that to preserve that, to make sure it's not lost?
It's everything. It's everything to who we are and the history of this state more than anything, and of this city. And yeah, so there's no two ways about it. The importance of that heritage is so important.
Thank you.
And it should be looked into, if anything. And I know Jagera, who is with the Yagara Mugajin Elders Group, she has tape recordings of her grandmother speaking traditional language, and that's how she is correcting all the incorrect information that has been written down before, and that's how she found out about Mugajin. So yeah, you know, even though it's been recorded as Mugajin, but her recordings of her grandmother is just, yeah, you can't put a price on it. You really can't. And she's speaking traditionally, yeah.
Sandra, Aunty Sandra, can you tell us about how Mugajin, the name, come about, and how there's a confusion with the other? Why is the two different names?
Mugajin means tulip wood tree, and the landscape of Brisbane was full of tulip wood trees, you know, as you said, and in fact, it is still on the footpaths of some of the city streets. You know, so that's where Mugajin actually come from, because of that. Meanjin is of one little circle of within Brisbane, and that Meanjin means a tree as well. So you will find most of the names, traditional names of people, are from trees and plants. So that's how that name came about, and it's been recorded in some of the history books. But it was when Kerry looked at it, she found it, and she said, oh, this is the name, yeah.
Go to the member for Cooper.
Thank you. Can I just ask, following up from the last question, Aunty Sandra, would the loss of cultural artefacts and heritage and history, do you think that would cause irreversible harm to you, to your community, to our First Nations people in Queensland?
To put Victoria Park as Olympic Stadium, it would destroy a lot of the history, because Victoria Park, that was a camping ground as well, you know, so a lot of people did congregate in that area, and because it's so close to Brisbane River as well. So to see something like that go up, it will affect the Aboriginal history of Brisbane.
And given that significance, would you have liked or preferred to see a comprehensive briefing offered to you and to your communities prior to the introduction of the bill, or alongside this committee process?
Definitely. We'd like to see something, yeah. Thank you.
Well, fortunately, this bill does set up that opportunity for consultation, and we look forward to seeing that delivered. Aunty Sandra, thank you for coming in at short notice, and we appreciate your input today. Unfortunately, the time has now expired for this session, so thank you. You haven't got any questions on notice, so there's no homework for you, so that's very good. But thank you for representing your community.
Much appreciated. Thank you so much.
That's okay.
All right.
Thank you.
Thank you.